Director Vidal is the Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office, where she runs one of the largest patent and trademark offices in the world with over 13,000 employees throughout the 50 states and Puerto Rico, underpinning more than $8 trillion in IP economic activity in the United States. She's been very active throughout her term with a number of requests, many of which people in this room have responded to, which we'll ask some questions about, and has led a multi-year effort to improve USPTO operations. She's revamped hiring and promotion practices, created the first ever agency-wide DEIA committee, and fostered a culture of opportunity for all, resulting in a 5% increase in diversity for the USPTO leadership in the last year alone. Along with Secretary of Commerce Gina Raimondo, Director Vidal serves as the Vice Chair of the Council for Inclusive Innovation, CI2, has created the first ever national strategy for inclusive innovation. She's co-chair of the Economic Development Administration's National Advisory Council on Innovation and Entrepreneurship, which created the first ever national entrepreneurship strategy. And she and Secretary Raimondo launched the Women's Entrepreneurship Initiative, and Director Vidal founded the Entrepreneurship Essentials for the Military Community. She also expanded patent and trademark resources in libraries across the country and free legal services for patent applicants, increasing the participation by women and other underrepresented populations to unprecedented rates. She scaled up the USPTO's childhood education and K-12 programming, introduced groundbreaking tools to identify IP and assist teachers, and she's made permanent the USPTO's outreach efforts through the creation of the Office of Public Engagement. Thank you very much for joining us, Director Vidal.
It's great to be here. Good to see you all. Thank you.
So we're going to start off with a bunch of questions that tie into a number of the panels we've had the last day and the panels we'll have going forward. And then, as I said, we'll turn it over to some audience questions after that. So artificial intelligence. AI is a hot topic, both from the perspective of innovations in AI technology and from AI use as part of the inventive process. What has the USPTO released recently relating to protecting AI inventions?
So let me just, this is really loud. Okay, great. I have to talk quietly. So let me just take it up a level. When we look at artificial intelligence, we are working across government on policy. And the bottom line is we need companies in the United States to adopt artificial intelligence. So we need to make sure that people know that it's safe. We need to create measures so that it's safe. And then we need to make sure that everybody has access to it, because all the great work that we're doing using intellectual property to democratize innovation, to get more people into the system, is not going to come to fruition if only the incumbents have access to artificial intelligence. So when we implement policies, we keep in mind those goals as well as first principles. We need to be as clear as possible in order for systems to work. So when you look at the work that we're doing, we released inventorship guidance because we thought the next test was going to be, what if you use AI but name yourself on a patent? What happens then? So we wanted to make sure the examiners were clear on that and the public was clear on that. We received feedback on that. We're going through it now. It's possible we could be more clear on that. So I'm actually I've been working on this for the last month and a half, reading your comments, and we may either tweak it or provide like kind of an FAQ to the guidance to make sure that people understand that we are aligning with the law. We used PANU for that because it was a nice way of looking at relative contributions, the contribution from a human and the contribution from AI. And we used the language from the Federal Circuit on that, which I think has misled people a little bit, because the Federal Circuit used the term significant contribution, which we have not changed the standard at all. It's still the standard in terms of contribution. So we may provide more clarity on that. In addition, for patent eligibility, we know that the patent examiners want examples. They want to benefit from the same framework that judges benefit from when they're making decisions. So we released guidance on that. And then certainly we released guidance on use of AI before the office, because again, we do see it as a democratizer. And to the extent that people can have more access because they can use AI and reduce their expenses, we want to encourage that, but at the same time, we have to hold them to the same standard. So on that, basically the bottom line is whether you're associate is hallucinating or AI, you're responsible. So that's what we've released recently. Certainly the Copyright Office has released a report when it comes to AI and copyright. We are working on ours. I believe that should be released in about the next month. It's going to very closely align with what the Copyright Office has done. All of our work very closely aligns, really calling for legislative action when it comes to the output of AI. So that's upcoming. We're also exploring many issues nationally and internationally on AI.
Thank you. I think you hit on all of the AI questions I had prepped. I'm sure we'll have a bunch more from the audience a bit later in today's session. So moving to inclusive innovation and robust IP protections, our theme for this year's conference is the importance of exclusive rights for innovators and creators. Can you elaborate on the initiatives the USPTO has implemented or is currently developing to promote inclusive innovation and the importance of IP rights to underrepresented communities?
So I will say that this is a national imperative. I actually spoke with Secretary of Commerce Gina Raimondo yesterday at the CHIPS conference, and we both orient to it that way. She looks at it as an economic issue. I think of it as both a moral issue. I've always believed that everybody should have the opportunity to participate, but I also think it's a national imperative when it comes to economies and lifting communities. If you look at the work that we've done, we again have raised it up a level. We've issued the first ever national inclusive innovation strategy. We've also released the first ever national entrepreneurship strategy, which was really meeting people, talking to venture, talking to others, and figuring out where are the stumbling blocks. Why are women funded at 2%? And oftentimes when we think about women, it's a surrogate for racial groups, it's a surrogate for rural communities, for people in the military, anybody who's not fully participating. And so we've released that. If you look through it, you will see a lot of initiatives that we've undergone. The bottom line is we're only going to be our best. We're only going to optimize our potential as Americans. We're only going to stay ahead competitively if we make sure that everyone is participating. I love the nod. So, and I will say, when I go to other countries, they're focused on this as well. They're watching our efforts. Every other country says we're leading when we're in meetings with them, but they're learning from us. When we release things publicly, they're watching. They know, every country I've met with knows they need to get more women into the system. Countries define diversity differently, so that looks a little different country to country, but they have similar initiatives. And even in China, where they're not as focused on the economic prosperity part of it, they're really focused on succeeding in women and winning with innovation. They're also focused on making sure more people are participating. And I could go through all of our initiatives. You'll find most of them in the strategy that we release, but we are knocking down barriers everywhere, including when people file for a patent in the office.
Thank you. The U.S. IP Alliance, which I'm on the board of, and SIP Squared and the USPTO are both partners with, is promoting October as IP Month. DC and Maryland have officially made October IP Month, following on a number of prior states, starting with Georgia. Do you have anything to add about the importance of IP to the U.S. and why we need broader recognition of the value that IP brings to the economy?
So I'm really excited about IP Month. We're going to be releasing a statement about October to support the efforts of US IPA. We're doing things. We're going to be releasing, I believe it's going to be both the IP identifier, which helps people identify and understand IP, as well as a recent certification that we created for startups, where we're going to get out there and certify startups that they're being smart about IP. We're then going to try and reach out to the venture and other communities and say, don't take a meeting until you direct startups our way, so that they can go through this training. And the training is not just about register your patent, think about your copyrights, think about your trademarks, think about your trade secrets. It's also about make sure that people don't steal your IP through cyber theft. And here's ways that you can do that you can afford as a startup. You can't really be NIST compliant as a startup, but there's other procedures you can employ. And then the last part of that is about suspicious funding sources, because we know that there's funding sources from out of this country who are attempting to take startup meetings and then steal the technology, or they invest a little bit in a company and then all of a sudden the technology is offshored.
Thank you. One of our panels earlier today focused on how copyright supports individual creators and the dissemination of knowledge to society as a whole. Some in our audience might be surprised to learn about the USPTO's involvement in copyright policy. Could you shed light on the current copyright-related projects or initiatives the USPTO is working on? How does the USPTO work with the U.S. Copyright Office and others in copyright policy?
The division really between the Copyright Office and the work we do is they do all the work with registering copyrights, and certainly as an expert agency on copyrights, they also advise Congress and play that role as well. We are the presidential advisor and the advisor to the entire administration, the executive branch on copyright and every other form of intellectual property. So with that, we do everything in step with the Copyright Office. They're an expert agency. We have experts within our agency as well that work with them. So if you look at the portfolio of our work, it's, I worked with Shira Plurimutter when it came to the executive order, what should be in the executive order, and how should we collaborate on that. We're on the request for information that the Copyright Office introduced around AI and copyright. We worked with them on that and gave them feedback on that. We gave them thoughts on the report. It was their report. They do their own work, but we provide advice to them. They provide advice to us on the work that we're doing. And then beyond that, certainly we work in WIPO. We do international meetings, often together. And then we do advise the entire administration. That means USTR. It means the White House. It means every time there's an international treaty. We're there weighing in on copyright. Everything from should we get more voluntary commitments from should the president ask for more voluntary commitments? Anything that relates to the administration, we're there advising, but we do everything hand in hand with the Copyright Office.
Thank you. The USPTO has pro bono programs and a clinic program, which we used to have a clinic at the law school. It's currently on hiatus. Hopefully it will come back soon. It helps innovators file applications. It'd be difficult to expand such programs to litigation, given the general cost of patent litigation, although there has been some discussion on and off over the years of a small claims patent court, perhaps similar to the relatively recently set up CCB. I haven't seen anything on this after the Administrative Conference of the United States reports from 2023. Have there been recent discussions along those lines, and other thoughts on small claims patent court?
So this is something that we worked with the PPAC on when we first got that report, and I think it's challenging right now given the state of everything. So the thought from the report is if there is a small claims court, it needs to live somewhere. And two of the places it could potentially live is with the PTAB or with the ITC. I think both of those present their own challenges. I would like to see the dispute system be more efficient. I'd like to see the access be greater. I don't know whether the small claims type court is the right way of approaching that. Certainly we've been working with the Copyright Office because it works well at the Copyright Office, and so we've been working with them to consider that. Part of the issues are it's still expensive with the PTAB, and right now there's some trust issues with the PTAB when it comes to the small inventors who would actually use the process. We're working to fix those. We could not fix those through rulemaking within this term, but it's still on our minds. We do need to do an economic study, which we are engaging in. We need to figure out how to solve for the small inventor issues while not emboldening opportunistic behavior, which some people refer to as patent trolls. And so that's something we're working with the PPAC on and are trying to figure out what are the next steps to set this up in the nice arc that we set up for the first, for this term, so that that work can be done, the economic studies can be done, and it can be pushed, across the finish line within a term. But while we're at the state that we're at, we're not really in a position to move forward any type of small claims court, but we are always listening. So if you think there's opportunity, if you have solutions, you can email me directly at director@uspto.gov. You can talk to our PPAC members. We're always happy to hear if you think there's a great way to thread the needle.
Thank you. Moving to international, your role involves significant international engagement, including your recent trips and the USPTO's Global Attaché program. How do those global efforts impact or inform domestic patent policy?
So I will say this is some of the work that we do that gets the least amount of attention. Part of the reason it gets the least amount of attention is because a lot of the work that we do is interagency. So we don't go out and talk about the work that we do. We really negotiate across U.S. government with the White House, with USTR, and then we get involved in treaties and other international work. Part of that is trying to embolden the global South with intellectual property, with having them realize that a strong intellectual property system is a benefit to them. Because right now in treaty negotiations, what we hear generally from the Global South is that they need forced tech transfer, that they need to transfer US and other sophisticated countries' technology and patents to them so that they can create drugs, they can solve for environmental issues, et cetera. So we're trying to change the narrative on that and help them understand the importance of IP. And so a lot of the work that we do, including through the attachés, is on that. We also are doing a lot of work, and we're doing work across the globe. I'm just hitting some of the highlights. A lot of work with China. My trip to China this year was extremely productive because a lot of times it's about the relationship. And the fact that Vice Premier Ding, who's number 3 in the entire country, invited me in to have a dialogue, and the fact that he was very open, it was a very polite dialogue in the beginning, and then I said, would you mind if I share stakeholders' views? And then I laid it all out. That really opened the door to the team following up on those efforts from the commitments that they made when we were there. We're able to make progress in China as well. We've commented on about 145 legislative measures in China in the last couple years. So we are moving the needle. We've increased damages in China. There's a lot that's been positive. We have a long way to go, but that's part of the work that we do. Part of the work that we do, that's some of the most important work, is some of the work that you've seen not get across the finish line. So one thing I'm really proud of is that we did create an arc during this term, and everything that we want to get across the finish line is getting across the finish line. But what you also have seen is stuff not get across the finish line. You've seen the TRIPS waiver not extended to therapeutics and diagnostics. You saw in the WIPO negotiation, the WIPO treaty that was in the spring of this year, you didn't see forced tech transfer. You saw in the first part of the pandemic preparedness accord, that's still ongoing, the second part is yet to come, you did not see forced tech transfer. So a lot of our wins and a lot of what we're doing for the country is making sure that certain things don't get to fruition that could devalue IP.
Many here appreciate that. So given our audience and some of the topics from earlier today and later today, can you share any insights, particularly regarding standard essential patents and pharmaceutical-related issues on the international fronts?
Obviously, 2 very different topics. So on the pharmaceutical side, I've touched on a little bit of that. I will say that internationally, one of the biggest issues that U.S. companies is related to, again, a lot of it is in the Global South, and it's that they don't have the processes there that we have in the United States so that you can enforce a patent readily and stop people from infringing. So we've done a lot of work in that regard. We've done a lot of advocacy to really help those countries understand that they need those principles in order for pharmaceutical companies to operate. Because like I heard in Chile, there's a major pharmaceutical who's thinking about moving out because they don't have the right policies in place like we do with the FDA and USPTO. So what happens is if a branded company's pharmaceuticals are infringed, they have to go to court. And there are not preliminary injunctions or TROs that are readily accessible in court. We're also trying to fix that by getting judges together and getting US judges to empower judges in those countries to implement that. So it takes 6 years. So you're competing against yourself on the drugs for 6 or 7 years. The nerdy term is patent linkage. That's what they want to see in these countries. The other issue we're having on pharmaceuticals, which is a big one, is China. The one thing that they refused to negotiate on when I was there is the definition of new drug. They've defined new drug in such a way that a drug is not considered new unless you launch first in China. So they're trying to incentivize every pharmaceutical to launch first in China. And so that's a problem, but they believe very strongly in that. I was told in no uncertain terms they weren't changing that. We're trying to figure out other plans on that, but that's another issue that we're seeing with pharmaceuticals. Standard essential patents. So the first thing that we did when I came in was to withdraw the 2019 policy on standard essential patents, the 2021 draft policy on standard essential patents, and make sure the 2013 one didn't come back into play because we withdrew the 2019, which it could have. And that helped companies with standards in the United States because those were being misused by other countries against U.S. companies. Beyond that, we've created this Biden-Harris administration has created the first ever strategy on standards. We've been part of that. We helped create that and work on that. We just recently entered into an MOU with the UK to work on standards across countries, and we're using that as a model to bring in other countries into the dialogue. We've been actively engaged in the EU, really working on discussions around their policy, which I know half of you get excited about and half of you think is the most horrible thing on earth. So we're trying to figure out, what that looks like. If you're in the automotive industry, it's great. If you're Ericsson or Qualcomm, it's horrible. So, and then that has then emboldened China to work on similar things, which are not yet public. So we're in there talking to them about what we'd like to see and what the US would like to see on that. We're also engaged in arbitration efforts to try and move some of these disputes to arbitration. If it makes sense, that's not the be-all, end-all. A lot of it's going to happen in litigation, but we're working very closely with NIST and the whole Department of Commerce on these types of issues.
Thank you. So turning to tech transfer, we're hosting this at a university, and our closing session is on the Bayh-Dole Act. I don't expect you to comment on the administration's current proposal on it, but could you discuss the importance to universities' innovation? How has the act affected the value of licensing for universities as a start?
I mean, it's core to our economy and it's core to innovation. Like there's no other way to put it. We need the Bayh-Dole Act. It has to be strong in order for all of that system to work. It's most of the core technologies developed in the United States, about 50%, come from universities. We need to do more to embolden that system and make sure that we're getting more innovation to impact, especially through universities and university collaborations.
What trends has the office observed in the types of patents universities are filing?
So we don't particularly watch those per se, but I will say just off the top of my head, Google search, mRNA. I mean, the whole reason you got the COVID vaccine is because of Bayh-Dole. It's because of the mRNA patents on that were then used and built upon.
Okay.
Oh, and I will say, let me just say one other thing. The one thing that we're trying to work with universities on is to make sure that the research they do is VC-able, because a lot of times the fundamental research, for example, in the climate space, there's so much going on in universities around climate, but it's not VC-able. So nobody's investing in it. So part of what we're trying to do is connect the dots. So we brought everyone together for a Green Expo and tried to figure out why is the system not producing as much green technology solutions when it works so well in other areas. So we're focused on that as well.
Thank you. So turning to rulemaking and comments, the USPTO has been quite active recently with requests for comments and new guidance. Are there significant topics or upcoming initiatives that we haven't addressed that you'd like to highlight for our audience?
I think you've all seen all the work that we've been doing. If you're not familiar with all of it, we did, at the request of the PPAC, because they were having a hard time with their end of the year report, keeping track of everything that we're doing, we did create an accomplishments page. So if you go to a search tool and type in USPTO Strategic Plan Accomplishments, you'll see by category in our strategic plan everything that we've done. In terms of the listening and the requests for comments, thank you for participating. We use those, we act on those. We've teed up some recent ones, including about the research exemption, to set the stage for the next round of what is to come. And so we use it not just for determining what we can do, but for doing everything in a data-driven way, including negotiations with other countries, with other parts of U.S. government, with the legislature, for executive action. It's really important. Our work in the courts is informed by the comments that you give us. And we're still working on everything from 101 to, we released a lot in the PTAB area on director review. We're still working on getting the discretionary denial package out. On expanding the bars. I mean, everything that we've done has been with your input, so thank you for that.
Thank you. For those of us who regularly respond to requests for comments, what's most helpful, and what else can we do to help you do your job?
Specificity. The bottom line is we want to hear your thoughts, but we also want to know what the solution is. Just saying you don't have the authority doesn't do a whole lot. I will say that we don't put it out if we don't know that we have an argument that we have authority, and we run everything that we end up doing through the Department of Justice. And so we're going to be bold if we think it's going to make a difference for the country. We need to hear if it's not right for the country, and we will listen to that. We will not move a package forward. We will not move an initiative forward. Some of the ideas in our request for comments are ones that we think are good ideas. Some are ones where they've come from stakeholders, and we don't want to impose our own judgment. We want you to tell us. And I know sometimes that's frustrating because people think, oh my God, the sky is falling. It's not. We're listening. If you look at what we've done, it's been very precise and particular, and sometimes you commenting not only helps us decide not to move something forward, it kills it more broadly than the USPTO. So please provide comments on everything we put out there. It's terribly important for the process.
Thank you. I've got a couple of more questions, particularly for the students in the audience. But if those of you who have questions want to get up to the microphones and get ready, we'll be ready in a couple of minutes. So for the students and alumni in our audience, could you provide insights into career opportunities at the USPTO? What advice would you give for those at the beginning of their careers, as well as those more experienced who might be interested in working for the office?
So the way I've put this before is, I mean, we are a $4.3 billion organization with 14,000 employees. So think about all the roles that you can envision for any organization of that size. We have those roles. So I realize this is more of an IP-focused group, but we've got everything from accounting to human resources. So anything that you can imagine, you can do at the USPTO. You know, beyond that, we're certainly expanding the hiring of patent examiners. We want to bring more in, but we only want the best. I mean, this year we hired about 900. 20,000 people applied for those 900 jobs, but we chose the best of those 20,000. I will say, when you think about positions, I would think more broadly than the USPTO. I would think about what resonates with you, and even if you don't want to leave your current position and you're happy with it, there's a lot of committees you can serve on. There's a lot of work that you can do for the country right now through committee work and through other work, maybe housed in the USPTO or other places in U.S. government. So I'd encourage you to, when you know people in U.S. government, feel free to email directly and find out, follow U.S. Jobs, follow the various social communications that people put out.
Thank you. Specifically for the first and second year law students in the audience, could you share information about current or upcoming summer internships and school year externship opportunities?
So we have so many of these programs. Some of them are paid, some of them are unpaid. We post them, again, stay tuned for them. We have everything from if you want to work in trademarks, if you want to work in policy. We've got an Urban Alliance program. So there's so many different initiatives and opportunities to get involved. And if you get lost at any point and you don't find the information readily on our website, which we've completely redone to make things more accessible, feel free to email me directly.
Thank you.